I want to introduce our guest speaker today, Jeff Belomo. Jeff is a personal friend of mine. I actually attend a continuing education class with him every year. As a CFP, he provides, or I'm a CFP. I go to his classes to get CE credits for my CFP. And he spends roughly a whole day talking about elder care, taxation, estate planning, and sometimes those interests do compete, Jeff, and we have to figure out the goal of the client and then make the best decision for each individual circumstance. Jeff, do you want to give a little bit about who you are and your practice?
Sure. I always do this at the risk of people shutting down and going, "Oh no, this guy's going to be boring." I do have a master's. I do have a master's of laws in taxation. I'm a certified elder law attorney. I have a certificate in estate planning. Essentially, all that means is that this is what I do for a living. We pretty much only do estate planning and elder law, and that is all that we do in our practice. And essentially, that's all that I've done for pretty much my entire career. And we'll talk a little more about that today.
Perfect. So we did get a few questions in advance, so I wanted to start with those. Jeff, there's two questions in particular that I receive a lot, and I'm looking at the list of attendees, and we have a couple of advisors out in the Pittsburgh office that joined in, as well as my colleague Brad Newman in the Harrisburg office.
Awesome, welcome.
I'm sure that they receive these questions a lot as well. So the first one was, should I gift my house for $1 to a child or to 2 children? And I have the same reaction when they ask that as well. They've probably heard from friends that if you gift it for $1, the nursing home can't come after it. Do you want to expand on that, Jeff?
Yeah. How much time do we have? No, that was a joke. Well, and let me start one thing before we even kind of get into that, which is, as Bryson mentioned, I have been fortunate or unfortunate, I guess, depending on your perspective, to be able to teach not only continuing education credits to advisors and healthcare professionals, but also to attorneys across the country. So I've enjoyed it. I've loved it. When we took a look at the questions that you guys had sent us before the event started today, I literally laughed out loud, because when I present nationally to attorneys, I put a list of questions on the board that we're going to discuss. And literally what you asked was what I put on the board. I mean, I literally don't think there was one question that I usually put up that wasn't there. And the reason I bring this up is because when I teach nationally to attorneys, I'm typically teaching for 4 days. I typically start at 8 a.m. and I end at 6 or 7 p.m., depending on the day. And so the reason I bring that up is we're not going to be able to cover 100% of everything today. In 1 hour, we'll certainly cover the highlights, and Bryson and I are going to cover the things that certainly impact us the most, but also the questions that we received. But please understand that if you leave here today not fully grasping everything, that's okay. You can reach out to me, you can reach out to Bryson, and we're more than happy to continue the conversation and to continue the education. Heck, we have educational opportunities 10 times a month that you can listen for 2 hours for free and probably answer all of the questions that you're looking for. So I wanted to start with that. All right, so now to the question, should I gift my stuff to my child for $1? So before I'm done kind of convulsing, I want to introduce you to something that I call my 3 lands. So if you could imagine this for me, if I'm in a room live, I'm literally walking around the room. And I know, Bryson, you've seen me do this numerous times. If you can imagine for a moment that I'm in the left-hand corner of the room, that would be tax land, TAXLAND. All right, now I'm in the middle of the room and I'm in long-term care land. And now I'm on the far right-hand corner of the room and I'm in estate planning land. So I'm going to give you a common definition of estate planning just for the purpose of keeping things moving today. What I hear most people tell me is, Jeff, I want to control my property while I'm alive and well and plan for me and my loved one if I become disabled. All right, so control is huge, right? We don't want to give up control. We want to remain in control during our life, and then we want to plan in case we become disabled so that decisions can be made financially, medically, our end of life decisions, which ties us into our powers of attorney for medical, for financial, and also our living will. All right, so now I'm going to head back over to tax land. So let me give you some basic tax rules that I want you to remember. Under the current federal estate tax exemption amounts, you can have $11.58 million. You could transfer it during life or at death, and there will be no federal estate tax. If you are married, you can multiply that by 2, so it would be 11.58 plus 11.58. In addition to that, an individual can give what is called an annual exclusion gift away every year, and that's per giver and per receiver. So that's a huge gift. 15,000 doesn't sound like a lot, but when it's per person, the husband, per person, the wife, and then to the children, and then you can give to the spouses of the children, you can get over $100,000 in a year pretty quickly without a lot of beneficiaries. So what that means, essentially, what I just told you is that you could give away what? Everything. I mean, I literally just told you you could give away everything you own tax-free, because I don't really represent anybody who has more than 11.58 plus 11.58 plus the annual exclusion amounts per year. So woohoo, right? So from that perspective, the answer to the question is, yeah, sure, go ahead. From a tax perspective, what the heck? Okay, now imagine me riding a horse, okay? So I'm riding a horse to the middle of the room. I'm in long-term care land. All right, brief overview of long-term care land in Pennsylvania, which currently says that if a spouse enters a nursing home, if you work with somebody who knows what they are doing, and notice I caveated that, if you work with somebody who knows what they are doing, we can protect 100% of the assets for the spouse who is residing at home. Was that a stutter? No. Was that a mistake? No. I did say 100%. And if an individual is single, widow, or widowed, we can protect 50%. So that's in a nursing home, not having done any planning, and now what am I going to do? What opportunities do I have? Okay, but before the state of Pennsylvania is going to help us, and before the state of Pennsylvania is going to allow me as an elder law attorney to do that, we're looking back. How many years are we looking back, guys? 5 years. And what are we looking for? Gifts. Wait a minute. That overweight curly-haired attorney, you know, Jeff, he told us on that presentation that we could give away everything, because 11.58 plus 11.58 plus that annual exclusion gift, he told us we could give away everything. I absolutely did. In what land? Tax land, right? Okay, so I'm sneaking over to long-term care land now. We're not in tax land anymore, Toto. We're in long-term care land, right? So the reason I say this is because I look at estate planning and elder law very much like physics. For every action, there is an equal and opposite reaction. And Bryson mentioned it earlier, and I think it was actually brilliantly stated, and I want to repeat it, which is there is no one size fits all. Estate planning has to do with a person's goals. What do they want to accomplish? Because clearly, tax land, long-term care land, and estate planning land are not one and the same. They're competing. How do I know? Well, because if you give it away in tax land, a gift is non-take-a-backable. All right, one more time for effect. A gift is non-take-a-backable. If I give it away, how well do I control it in estate planning land? The answer is you don't. Now, my father was a lot like many of you. Jeffrey, I trust you. I trust you. Guys, this isn't about trust. Bad things happen to very good people. Please don't ever forget that. So if my dad puts my name on the deed to the house, who owns the house? I do. Subject to my divorce, my car accident, my stroke, and my subsequent nursing home, and even my death. If I die, who is probably going to get everything that I own? My wife. Will my wife let my dad live in his house for free that she now owns? Yeah, probably. Okay, let's fast forward 10 years. Will my wife's new husband allow his ex father in law to live in a house that he owns with his wife for free? I, I don't know. I'm not certain, but I'm pretty sure that when my dad put my name on the deed, he didn't expect to lose it because of my nursing home, my car accident, my divorce, or because of my death and my wife getting everything. So please remember that bad things happen to good people because they really do. The other thing that people don't realize is the tax potential consequence that you are creating. So let's just do a quick go back to tax land for me. Okay. If a person gives the house to their child, the basis that their child has, basis is just a fancy word for saying if dad paid 50 grand for the house, the basis that I receive is 50 grand. It's called carryover basis, which just means I get the same basis that my dad had or the person who gifted it. Now, if I sell it 5 years from now, from 50,000 to 250 to 300, whatever it's worth today, there's a gain. Okay. Now, if I live in that house for 2 out of 5 years, I won't have to pay it because there's an exemption amount there. But typically, children don't live in the parents' house. They have their own house. They're living somewhere else, and they're just well. Now there's capital gains tax implications. 15%, 23.8%, right? It all depends on the income that I have. But a lot of this type of planning is done when the parent is in their 80s and the kids are in their 60s. Well, what's the highest wage earning years for the kids? Potentially their 60s before they retire. So now my wages are up because we're close to retirement. And now I'm selling this house and having all this capital gains tax. The one comment I'll make is Pennsylvania inheritance tax. Yes, there is a tax in Pennsylvania on the transfer. Basically, it's on the transfer of the wealth. I think the statute actually says on the privilege to transfer wealth in the Commonwealth, but whatever. The rates 0 to a spouse, 4.5% to lineal descendants, children, grandchildren, parents, grandparents, 12 to siblings, which is, kind of side by side, and then 15% to anyone else, including nieces and nephews. More people come into my office worried about avoiding that 4.5% tax to kids over probably anything else. And I would like to just take a 30-second window here, public service announcement, to tell you that that 4.5% is a nuisance. It's nothing more than a nuisance. In the grand scheme of things, the ability for you to control your property and be in control of it, whether that means it's in your name alone or whether that means it's in a trust that you control, you controlling it is more important than anything. I'll give up the 4.5% tax because what I get in return is a step up in basis. So if my dad has it in a trust that he controls, or it's still in his name at his death, assuming he doesn't run into the long-term care situation and run out of assets, I will get it at his death. I will pay a 4.5% rate, but I'll get a step up in basis, which means I'll pay 0 in capital gains tax or very, very little from the date of his death until the day that I sell it. So please, please, please do not gift your house for $1 to your kids. There are way too many consequences that are irreversible and you are giving up control. Please do not do that. Okay. How was that, Bryson? Too long?
No, I think that's perfect. And what I always tell clients when they ask that question after I'm done shaking is I'm glad that you asked before you did it.
Yeah.
Anytime you have a chance to make a financial decision, talk to us, talk to an advisor, talk to the attorney. We don't charge extra to field a question.
No.
Give us a call. And again, it's all about what is that prioritization, because I can't, as an advisor, put my morals, my ethics, my priorities onto the client's situation. We need to talk about what the client's goals, objectives, ethics, morals are, and then find that customized solution for them. Because
Yeah.
what might be right for you and your wife could be different for me as a single male, which then leads us into the next question, Jeff. I'm married. Do I need a will? I'm single. Do I need a will? Well, I can tell you
Yeah.
that it's well worth my time and effort and energy and a couple $100s to get a will made up. I've seen people try to make their own wills. That's a whole different caveat. But the first question I ask the client when they make their own will is, did you provide any guidance or any discussion about how to handle minor children? So maybe let's expand and beyond just, do you need a will as you're married, but who needs a will and why would you need a will?
I mean, I wholeheartedly believe that every individual over the age of 18 needs a will, just period, blanket. I don't care if they're single, married, children, no children. To me, there's so much that can happen in life, right? We call it life for a reason. And you don't know what the situation is going to be on the day of your death. There's property, even if you're married, that would be owned jointly by individuals. Not everything is always owned by the married couple. So please don't think that because you're married or because you're single, you want to direct what happens after you die for a whole series of situations. Who is going to be in charge of that situation? The state has a rule book. It's called intestate succession. The state will fill that gap for you. But I can tell you from experience that it is never what the person wants. I'll give you a case that happened to me, and it was my best friend's family, where the husband and wife did not get a will. First marriage, they have 3 kids. And I guess they just assumed they didn't need a will, right? Because they're married. So why would they need a will? And he dies. Now, the 3 boys, the 3 children, they came into my office and said, yeah, everything obviously goes to mom. Well, under the intestate succession statute, the first 30,000 goes to mom, but everything else gets split 50-50 with the kids. And she didn't have enough money to live. And ultimately, the boys did give all of the money back to mom. But that's a situation where A, they were able to, B, there was still harmony in the family, but C, had any one of those kids been in the middle of a divorce, had any one of those kids been in a car accident, had a stroke, a nursing home, a death, you can't count on people just giving money back to you. So please don't rely on those states' rules. They're not what you're going to want. The people aren't going to be the same as to what you're going to want. While it's better than nothing, it's not much better than nothing. So please put your wishes in writing in black and white. Provide a backup, right? Please provide a backup for the executor. If the person that's carrying out your wishes passes away, make sure you have another name. And if there's an obvious choice behind that person, name that person. You always want to try to predict just in case something happens. I have a quick kind of story I do. I know you've seen this one too. My 2-finger test, right? How many of you out there have heirs? HEIRS. Oh yeah, right. Anyone have disabled heirs? Okay, a couple. Anyone have minor heirs? All right, a few. We're all wrong, right? Take your 2 fingers, put them on the inside of your neck. I think you're going to feel a bumping sensation. If you don't, just raise your hand and Bryson will call 911 and we'll send an ambulance to you. Heirs are not determined until death. And while you're alive, we don't know who they are. So just because you don't have a disabled heir today doesn't mean you won't at your death. Just because you have a minor heir today, or just because you don't have a minor heir today, doesn't mean that you won't at your death. So I even go a step further than what Bryson said. I mean, Bryson said that the do-it-yourself wills is a little risky. I take it a step further and say working with a general practice attorney is equally as risky, because I do a story where I call it my psychic story, and I actually read your will to you, which I'll save the time today. But usually they're about a page to 2 pages, and if you really work with a sophisticated attorney, there's going to be a provision that says And in the event that someone's a minor, the money goes into a uniform transfers to minor account, which is better than nothing. But all that means is they get the money at 21. So I remember how I was at 21. I don't think me inheriting a lot of money at 21 would have been the best decision that ever happened. So please don't assume that you know what your heirs are going to look like. Please don't fall into the trap of thinking that because you are married or because you don't have kids, you don't need a will. Yes, you do. You still own property in your name. And even if you don't today, you will potentially tomorrow. So please take care of that. And I'm going to take that one step further just to cover another point that I always want to make. If you don't have a financial power of attorney, please get one. A financial power of attorney authorizes another individual to make decisions on your behalf. And no, just because you're married doesn't mean you don't need one, right? And I'm going to prove it to you. Even if you're married, you might have a car in your name alone, right? I have a car in my name. Well, if I become incapacitated today, can my wife sell my car tomorrow to help pay for the bills? Why not? Because she's not an owner on that account or on that title to the car. And even if she was today, if she died, she won't be tomorrow. So please have that financial power of attorney. Retirement accounts, right? How are they owned? They're owned individually. Like, what's an IRA stand for?
Oh, I know.
Individual retirement. Yeah, yeah. Individual retirement account. Who owns it? The individual. Well, gee, Jeff, my wife is the beneficiary. Sure, but what has to happen for your wife to get it? You have to die. We're not talking about death. We're talking about before you die, who's going to make those day-to-day decisions. So everybody over the age of 18, including those kids going off to college, if mom and dad call the school to ask for information about the bills or about grades, if there's not a financial power of attorney in place, they're not talking to mom and dad. And I don't care if they're paying the bill for the kid. You need a power of attorney. So please, everybody out there, get yourself a will and get yourself a financial power of attorney. Now, I also recommend a medical power of attorney. But again, the state has a rule book for you if you don't have one. So it's better than nothing. But that essentially says, hey, don't worry. Your new spouse and your kids to a previous relationship, they'll hold hands. They'll sing kumbaya when they're making medical decisions in the hospital. Yeah, maybe not, but at least there's something. At least the next of kin can make decisions. So again, please have a financial power of attorney, as well as a last will and testament.
And Jeff, we do have some clients on the webinar right now that have children that are not quite college age. A lot of times when we start hearing people say, hey, my kids are getting ready for college, that prompts us to talk about a healthcare power of attorney. I know from a personal experience, my dad took me to the hospital. I'm in the emergency room with my father, and they denied him access. Now, I have a healthcare power of attorney, but I was able to provide the verbal, I want him to come back with me. But he has that healthcare power of attorney on his cell phone that he can show any medical practitioner. My son has provided the authority that I can be involved in these decisions. So I've seen it, unfortunately, as an RA in college where parents are unable to get involved with healthcare decisions. So
yeah, and always remember, just because there's a healthcare statute doesn't mean that you're not going to have to fight, doesn't mean that you're not going to have to argue, doesn't mean you might have to not hire an attorney. Just because there's something there doesn't mean everybody knows about it, doesn't mean everybody believes in it. So please don't rely on it.
we have that with the financial powers of attorney. We've seen that a lot where a bank won't acknowledge them. And you've been involved, I'm sure, numerous times where a financial institution does not acknowledge the power of attorney. Do you want to kind of elaborate on that a little bit, Jeff?
Yeah, sure. I mean, I'm a history buff as it relates to law, so I'll give you a quick story. There was a case several years ago in Pennsylvania prior to 2015. I want to say it was 2013 or 2014, where an individual used the power of attorney. It was a spouse in a bank, and they accepted it. And turns out that the notary was forged. So ultimately, the bank is held liable, and there's a lot of litigation that occurs. And at the end of the day, what ended up happening was they held the bank liable essentially and said that the bank had a reasonable duty to investigate the validity of the notary. Now, come on, are you kidding me? Can you imagine being in a bank and a teller yelling, "Excuse me, everybody in line, I'll be back in 30 minutes. I'm going to go take a look at this POA and investigate its reasonableness and its validity. So just hang tight." It's the dumbest thing I ever heard. And unfortunately, bad facts make bad law, which is a phrase that we always used in law school. And pretty quickly, as soon as that case was over, the Pennsylvania legislator jumped in and said, "Oh, no, 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 no. If an institution reasonably relies on something, believing it to be valid, we're going to hold them harmless. We're not going to make them liable." But the problem is the courts already held them liable. They already lost the money. So by changing the law later, it doesn't help them. It's kind of akin to opening the barn door and the horse running out to pasture and then closing the door. The horse is out. It's too late. So the banking industry really got nervous and they said, "Well, now wait a minute. We know you changed the law in Pennsylvania. We know that other states changed their laws, and we know that we have indemnification now. But where were you when this happened? Where were you when this idiot judge," I hope there's no judges out there. Anyway, "where were you when this idiot judge made this decision?" So my 2 cents is what you're seeing now, which is what Bryson just referenced, is banking institutions, financial institutions, they're just scared. They're protecting themselves. So we're finding people and institutions telling us that if it's not updated every 6 months, it's not valid. Now, that's the dumbest thing I ever heard. It's not in the law anywhere, but it's their internal policy that they're creating to protect themselves, which frankly, I don't blame them, right? And a lot of these institutions aren't just in Pennsylvania. So just because Pennsylvania has this statute that says we'll hold you harmless, a lot of other states don't have it yet. So that's what you're seeing. You're seeing banking and financial institutions wanting you to sign their own, and you should. If you have capacity, there is absolutely no reason not to sign the one that Bryson and his team is going to ask you to sign, or the one that the bank's going to ask you to sign. No sweat. But it's when you don't have the capability of signing it again that I want to make sure that I have one that's valid, that is in place, that I can argue that they have to use it. But in the meantime, if you have capacity, just sign whichever ones you need to.
Yeah, like Schwab, Fidelity, they have their own, and we use those as needed. And the other advantage of having a team of advisors, not just financial, but attorney, accountant, when that situation pops up, "Hey, Jeff, we have a common client in Jane Smith. She's not able to get something done at Schwab. Can you get involved?" "Yeah, I'll take care of it." Problem solved.
Absolutely. Absolutely. And with technology, we can have that POA over to them within a minute. I mean, it literally, it's so easy nowadays that having people to have your back is the phrase that we use. Is you can't put a price tag on that. It's amazing.
So Jeff, another question that came in advance was trying to avoid some inheritance landmines.
Yeah.
And that, I mean, that's a very big, broad topic, but any best practices there for the group?
Yeah, I saw that question right as we were getting online. I missed it earlier when I was prepping, but part of it, I think the biggest landmine is the one that we just talked about, which is about putting the kid's name on the house for $1. People are trying to avoid the inheritance tax, or they're trying to protect the asset from a long-term care situation, and they're losing sight of the bigger picture, right? Yes, you can avoid 4.5%, but what's the risk that you're now subjecting your children to with the capital gains rates and with the capital gains tax? And in my clients, in my situation, 90% of the time, it's better to pay the 4.5% tax. It actually makes sense to pay the inheritance tax to avoid the capital gains tax for the children. That's probably the biggest one that I'm seeing. The other one that you just kind of want to remember is taxes aren't always bad, and I alluded to it earlier, but I think this is a nuisance tax. A lot of states will charge 30, 35% tax. 4.5%. I mean, it's more of just an annoyance than it is anything else. So trying to live your life, trying to avoid it, I think is the biggest trap that people fall into. And please remember estate planning land. You want to control your property while you're alive and well. I hear it every single day in my life. And then all of a sudden, the same person who just stresses that to me is the same person who comes in and says, I want to avoid this inheritance tax, so I'm giving everything to my children. What? You're giving up
Hanford.
control. Well, yeah, but it's worth it because I don't want to give Pennsylvania anything. Oh, great. So now we're potentially going to lose it, and the federal government's going to get more later. So inheritance tax to me is just a necessary evil, and I want that step up in basis. And so please don't spend your lives trying to figure out ways to avoid it at the risk of giving up control. And the one comment that I didn't make earlier that I missed that I want to make now is don't get cute and please don't think that the answer then, rather than put the kid's name on the asset, don't get cute and think, well, I'll just add the kid to the asset. I'll just add the person. I could go through the three lands again and give you three different answers as to what happens from a tax, a long-term care, and an estate planning situation where you have joint owners on the accounts. But the short answer is it actually is worse than having the kid's name, at least if the kid's name's on it. Assuming they don't die and assuming that they don't get in a divorce, they don't have a car accident, they don't turn on you, they don't screw you, at least with that gift, there's a chance after 5 years that the asset's protected, right? At least there's a fighting chance. When you add a kid's name to it, now what you've done is you have null and voided the 5-year look back period. Because even if that transfer was made 25 years ago, the state has the right to look at who contributed the money to the account. And 100% of that counts against the individual who put the money there. Well, don't get cute on me, because if you get cute on me, you're going to add your kids' names as a joint owner, and that actually is worse. So I'll spare you the three lands and I'll spare you the answer, but
Don't do it.
the reason, what's that?
Don't do it.
Yeah, talk to Bryson, talk to Jeff, talk to one of the other advisors at the company. I mean, it goes back to what we started with, which was you have to understand it from the three different lands perspectives. What's going to happen? What are the risks associated with each land? And then depending on your goals, your wishes, your morals, your ethics, your feelings, your personal decision making, that's what's going to decide what to do. But as a general statement, don't do it. That's my general statement.
Well, and that's why we have powers of attorney. They're not expensive to get. You can still have access to pay bills and help mom or dad out, but you're not subjecting yourself to the creditor risk, to the liability, to all the other host of negative ramifications. Jeff, one question did come in live during this about inheritance, and it was our favorite, the Secure Act, specifically regarding the stretch provision. So do you want to talk about that? I mean, it's kind of backed into a corner now, but.
Yeah, and feel free to jump in too, Bryson. I know you know as much about this, if not more. So basically, this is my twist on the whole story. Last year, we were able to stretch out the tax benefits of retirement accounts over a child's life expectancy. On December 23rd or whatever date it was last year, Congress changed the law as of January 1st. And essentially now when you transfer your retirement accounts to your kids, they have 10 years to realize 100% of the taxation. Now, there's exceptions for disabled and chronically ill individuals. There's an exception for minors who are not 18. But it's important to understand, though, that when they do turn 18, they have to realize them in 10 years from that date. And again, I go back to when I was 18 years old. I don't think me inheriting a retirement account outright would be a good idea. I really think that would have been a horrible decision. So what we're seeing happen now more than ever is a collaboration between the advisors and the attorneys, because you have to evaluate the children's situation. And in some cases, it may make more sense to not have it go outright, but to have it go in trust. And we may pay a higher trust tax rate. There's no question that we would pay higher taxes, but we would protect 100% of the asset. So there's a trade-off where I, as the attorney, would never make that call. I would bring in the advisor, we would sit around a table, we would talk to the client about what the situations are. The position that we're taking is that we're trying to put as much as we normally would have into trust, name the contingent beneficiary outright to the child or outright to whoever it is. That way we have an option. At the time of death, we can evaluate it with the family. We can run the numbers. And if the answer is we do want it to go outright, we have the trustee of the trust disclaim, and then it just goes straight through to the individual. They have 10 years to take 100% of the taxes. No harm, no foul. But if I have it go outright to the individual, there's no going back. I can't undo it. I can't put it in the trust. So this is an area where you really want to talk to professionals who understand the tax implications, like Bryson and his team, or me on the lawyer side, because everything's changed. It's a whole new ballgame now, and it also has some implications with planning, because now when people are doing their own planning, they're realizing, well, now wait a minute, I'm retired. I don't have much income at this point. Whereas if I give this retirement account to my kids in their 50s and 60s, again, their highest wage earning years, and they have to take 100% of the tax consequence, maybe I'm better off taking it over the next 15, 20 years, spreading it out and slowly taking it during my life. And again, that's going to be something that you're going to want to talk to your advisor and make sure that they're on the same page, and maybe your accountant or your lawyer, just to not assume, don't take that advice as what you should do. But I'm seeing the conversations change now. I'm seeing that we're actually running numbers to make those determinations. The other thing is, in the past, we were not putting retirement accounts into trust at all because we were triggering the taxes. And so we were leaving the trust out, having those assets be potentially available as a accountable resource to a nursing home situation. Now some advisors and attorneys are saying, okay, well, let's take a look at that. And if we were going to start taking slowly anyway, every year when we take a piece of it, we'll put it in the trust and protect it. It still takes 5 years to have it fully protected, but we might as well start doing that now rather than have the kid have to take it within 10 years and take 100% of it. So I don't know, do you want to add anything on the Secure Act, Bryson?
Yeah, so one of the things that we do annually, and the clients that are on the phone or on the web with us that work with Brad and I, Adrian comes in once a year, whether it's on the phone, whether it's a virtual meeting now, or whether it's face-to-face, and we go through the beneficiary designations. This is what triggers everything. And there was a lot of clients that had grandchildren as the beneficiary so that they could stretch it out. And part of that review has changed those beneficiary designations. So as we always point out, beneficiary designations are vastly important on your goals. It's a way to gift your individual retirement account, your 401k, to the next generation, or charity. We do a lot of charitable donations at the end of each year. But what we want to do is look at those on an annual basis, make sure things don't change. And the caveat I'll throw out, I didn't go to law school, so Jeff, confirm if I'm wrong, beneficiary designations trump the will. And what I mean by that is, if you die and your beneficiary designation does not match your will, it's going out based on the beneficiary designation. It's a contract.
Well, Brett, let me tie in our presentation topic today, which is how to protect your stuff in 3 easy steps. The 3 easy steps, the acronym that I use for 3 easy steps is ACT, A-C-T. So 3 steps, A-C-T. A is assess your needs and your personal goals and your family situation. C is complete your plan. And T is tie it into your life. And what that means is update your beneficiary designations, make sure that everything ties into it. So just doing a plan by itself with the lawyer is not enough. You have to have the lawyer and the advisor talking and communicating so that we can tie it together. So the entire presentation is 3 easy steps: assess it, complete it, and then make sure you tie it into your life. And frankly, I think the last one is the most important, and Bryson just hit on it. You can spend a lot of money for fancy papers, but if you don't tie it together, it's not worth the paper it's written on.
We've seen assets go out to ex-wives, to a whole host of different people that they didn't want, because even though we review the beneficiary designations, an old life insurance policy that they forgot about. And that's why we want to talk about all of your assets, not just the investment accounts that we have at Fort Pitt Capital, but what's your life insurance? What's your long-term care look like? What's your house registration look like? Tell us about your assets, because every part has a, it's a cog in the wheel, if you will. So,
yeah, and there's 2 types of assets in the world: probate and non-probate, right? So probate assets are any assets that are not non-probate. That's a joke. I'm kidding. Non-probate assets are assets that transfer by operation of law. So whether it's a jointly owned account, it's an insurance policy that I list a beneficiary, it's an annuity that I list a beneficiary, it's a payable on death account, a transfer on death account, an in trust for account. Those are all examples of non-probate assets. When I die, they go automatically based upon the ownership or the contract. So if the contract lists my old friend from 40 years ago as the beneficiary, my old friend from 40 years ago is getting everything and my wife's getting nothing. So pay attention to what the difference is between those two. Non-probate transfers by operation of law. Probate is an asset that you have in your name alone at the time of your death, with no beneficiary designations, with nothing else on it. That goes through your will, and your will goes through probate. And probate is just the state's rule book that tells us what we have to do in the state of Pennsylvania. One of the things that I learned from traveling the country teaching is that a lot of other states have some pretty horrible probate processes and some pretty horrible probate situations going on. Pennsylvania is not really one of them. The costs are very minimal. It's real easy. We don't have to have a court involvement. We can have a family settlement, just sign off on a receipt and release, and we can settle it all up. So I don't necessarily feel in Pennsylvania that probate is the devil or that probate is the end all be all. Again, talk to your advisors, talk to your attorneys. There are ways to tie all of this together into a nice package. And that way we have everything working together. And that's what you want to make sure. And the last comment that I want to make about non-probate stuff is I think that we all love our spouses and our family members way too much to just give them the money outright. And so I'm being a little funny. I'm also foreshadowing for you guys to want to come to a workshop to learn more about what the heck that's about. But the story in the workshop, one of them that I give is, if I give everything to my wife outright through non-probate beneficiary designations, which there's nothing wrong with, she now owns 100% of it. So if she's also now in a nursing home because of the car accident that I was killed in, she's going to lose all of it because she owns it outright. If she wants to just give everything to Biff the pool boy because she wants a pool and the pool boy talks her into giving him all the money, none of it's going to my daughter. So that's a little foreshadowing. And the only other comment that I want to make is non-probate has nothing to do with taxation. Non-probate does not avoid the Pennsylvania inheritance tax. There's essentially one asset that is unequivocally not taxable that Pennsylvania will not touch, and that is life insurance, right? Life insurance in Pennsylvania under any situation is not going to be taxable. But pretty much everything else, Pennsylvania is going to get their flesh on. Pennsylvania is going to get their portion. So please don't think that you're avoiding inheritance tax by non-probate designating everything. You're not. And that is a fallacy that people fall into. and they don't plan for it. They don't plan for the taxes to be taken care of. They don't warn the beneficiaries that they're going to have to come up with the money. So that's just one little tidbit, one public service announcement.
Jeff, I just had a couple more questions come in, and of course you mentioned the word trust, so you triggered somebody to say, what are the advantages of trust? What is a trust? Kind of a high level. And then the second one was triggered based on your will. So this one might be a little quicker and easier to answer. The actual question was, if we don't have a will, do you have a workshop that explains wills? And
Yeah. So our in-house workshop, in-house, we're giving it virtually right now because of COVID. So when I say in-house, I just simply mean that we do them on a regular basis. And we also have a link that we could send you that you could watch anytime. That is a 2-hour presentation, and we do talk a lot more about wills. We talk a lot more about trust, about non-probate. So we're giving a nice high level today. That workshop is going to drill in a lot deeper onto pretty much every topic that we've discussed today. And we'll give you all of kind of what the basics are and what needs to be in it. We certainly don't provide it for free, but we certainly talk about what it is and what are the important things to make sure are in it. Yeah, we definitely handle that in the workshop. And one of the things that we do in our office, and I'm pretty sure that you're very similar, Bryson, is at our end, if you're willing to come and listen to me or to Dan, or you're willing to watch one of our previously recorded workshops, anybody who can put up with me for 2 hours, I owe you something. So in return, we give you an hour for free of our time. And that hour is however you want to use it. A lot of people come in with questions. A lot of people show us their current estate planning. We're going to ask you what your goals are. We're going to ask you what you want to accomplish, because there's no way that we can guide you to how to get somewhere without knowing where you want to go. So, you're going to give some thought to that, but we do give a free consult, which allows people to ask specific questions and specific things about a specific case, and we're happy to answer it. If it works out that we're able to help, sure, we're happy to. But if now's not the right time or it's not the right situation, we're totally okay with that. So the trust conversation, as you kind of heard Bryson say, the other one was a little easier to address. I can probably talk for a good 3 hours, you think, Bryson, on a trust? I don't think it would be a stretch.
You could do more than 3, I bet.
Yeah, I probably could. So let me introduce the concept today, and then obviously the workshop would be a much better place to go. We spend about 45 minutes to an hour in every workshop talking about trusts, and today we'll probably spend 5 minutes. So obviously I'm going to give you enough that you kind of get your appetite whet, but I don't want anyone expecting that you're going to fully understand 100% of it. The way that we teach trust in our office is through the use of a radio flyer red wagon, right? How many of you had a wagon when you were a kid? Yeah, a lot of you. And what went in it? Whatever you wanted. Who played with it? Yeah. And who played with yours, Bryson?
I did.
Yeah. And whoever you wanted, right? It was his stuff. So while it could have been G.I. Joe figures and rocks and dolls and whatever, now instead of the G.I. Joe figures, it's your house. Instead of dolls, it's an investment account. Instead of whatever, it's something else. But this wagon is still what we keep close to us. It's still what we pull along. It's still what is important. So a trust is a contract between 3 parties. The grantor, the person who creates it, the trustee, the person who controls it, and the beneficiary, the person who receives it. What most of us know about trusts, we know about tax trusts. Tax trusts were very popular in the 90s and early 2000s when the federal estate tax limits were extremely low. I think I remember the day where it was 600,000.
Yep.
Well, now it's 11.58 million plus 11.58 million. Yeah, in 2025, it's set to come back to 5 million plus inflation. So maybe it'll be 5.8. But for most of my clients, if you're talking 11 million, most of my clients are still not going to have a major problem at that point. So we're not using tax trust nearly as much as we used to a long time ago. But I wanted to highlight the trust is the contract between the 3 parties. Now, if you're not worried about tax planning, you can be all three potentially. If you're worried about tax planning, then you can't be the trustee, but you can get asset protection. So when people ask me, do I need a trust? Again, it goes back to, what are your goals? What do you want to accomplish? Do you own property in several different states? And the reason we ask that is because if you own property in 4 or 5 different states, you potentially may have to go through probate in 4 or 5 different states, which would require lawyers and would require fees to the states and fees to the county. So right out of the gate, there are people who will do living trusts, revocable living trusts, simply to avoid probate. But if you don't have a bunch of property in a bunch of different states, you may not need to do that. You may not want to do that. If you want asset protection, then you're going to want to talk about an asset protection trust. And as I said, you can be the trustee. You can be the one who's carrying the wagon around if we're just looking for asset protection and not tax avoidance. In the trust that we commonly use, because you control the trust, it's going to be included for inheritance tax purposes, which I believe is a good thing. So don't freak out on me, because now we're going to get a step up in basis. So those highly appreciated houses and stock accounts and investment accounts that you've held on to for a lot of years, don't underestimate the power of what a capital gains tax hit can do to a child who wasn't expecting it or who was unwary. So there are about 30 to 35 different types of trusts that are out there. So a lot of what you're going to read on the internet, a lot of what your friends and family are going to talk about are actually not what we use. They're not what we do on a daily basis. And that's our biggest problem in our law firm. It's not other competitors. It's not other attorneys. It's misinformation, and not intentional misinformation. It's just that because there are so many different types, people believe that all trusts are the same. And the truth is they're not. They're not at all. And they're all very different, and they all serve different purposes. So when you're creating your contract between those three parties, who the grantor is, who the trustee is, and the beneficiary is, and what rights the beneficiary has, and what right the grantor has to change the terms of the trust and change who gets it, that all depends on which style of trust we're using. And believe it or not, even in our irrevocable asset protection trusts, the grantor can still change the terms, decide who gets it later. They can never change the fact that they can't give it directly back to themselves, but they don't have to give it to one child or another child. They can change that. So people are very surprised to hear that even in an irrevocable trust, the grantor still returns rights and reserves rights. So I guess that was a very short answer for saying, please come to one of our free workshops, no obligation, no cost, and you'll learn at least another 40 to 45 minutes of information about trust. So
I think from all the different times I've talked to you and plenty of other attorneys through different occasions, trust is a fancy word for being able to control assets in the estate planning world. And we've seen it for children with special needs so that they don't come off of public assistance. We've seen it for asset protection from nursing homes. We've seen it for, in rare situations, tax control. We've also seen it for when children have spending issues. If there's a spendthrift or someone who's very spendy, or heaven forbid somebody has, a bad habit that mom and dad don't want to fund. A trust is a fancy term, if you want to go to law school for 3 years, for control. And
yeah.
Again, it all comes back to that conversation of what is the goal, what are the concerns, what are the priorities, ethics, morality of the situation. And I don't know every type of trust. I know a few different types of trust from talking with you and other attorneys, but that ongoing dialogue with clients and getting to know a personal situation will trigger those conversations. I'll leave. We're getting close to the 1 hour mark, Jeff, but we had a client call up and said, my husband's going into a nursing home and all the assets are in my name. We mutually agreed that we're going to get a divorce to protect the assets from the nursing home. Well, you're chuckling because you know that that's not going to solve anything. The divorce would still have a 5-year look back from nursing home care, not from asset division or anything of that nature. And when I said, what is the goal? She goes, well, we're still in love with each other. We just don't want to use my assets to pay for nursing home. And I said, well, let's talk. Let's learn about your situation. Let's bring an attorney into the equation and find the right solution. And it ultimately turned out that they had a prenuptial agreement and a postnuptial agreement because it was a second marriage. But through that dialogue, we were able to uncover that, bring the right attorney into the equation, and solve the problem. So, I think the 3 steps, the assess your needs, complete a plan, and tie in your life, all wrap up into, if your advisor is not someone you feel comfortable speaking with and openly having a candid dialogue about serious matters, you need to reevaluate that relationship, whether it's the attorney, whether it's the financial advisor, whether it's the accountant, the insurance agent. But that's what we as practitioners strive to have, is that open, candid dialogue so that we can create a customized solution for everyone.
Yeah, and even on the attorney side as well, if the attorney you're talking to is not advising on the long-term care implications or the estate planning implications, get a second opinion. There are too many attorneys who live only in tax land, and while that's one land, that's definitely something we need to talk about. It's not the only land. So please work with people who understand the different implications of different situations, because too many of us live in one land and don't understand the implications.
And I won't claim to be an elder care expert, but with ongoing dialogue with you, I know enough to say that doesn't sound right. Let's pull Jeff in. Let's pull an attorney that specializes in and do it.
Amen.
And get that equation solved. So,
amen. Absolutely.
So Jeff, I really appreciate you being on the call. We'll keep it to an hour like we promised our constituents. And I look forward to continuing to work with you. And if anyone has any questions, don't hesitate to reach out to me directly. Don't hesitate to reach out to Jeff. His contact information is here. Odds are, if you call, you'll get a hold of Heidi. Is typically the person who answers the phone, at least for me. She's more than happy and helpful, delightful to work with. So I'd recommend that you look at Jeff's different webinars that he has. And obviously, if anything prompts a question, don't hesitate to reach out to me or anyone at Fort Pitt Capital Group. I appreciate everyone.
Thank you very much.
And thanks, Jeff.
Thank you.
All right. See you
guys.
Have
a great day, everybody.